Good afternoon, everyone. I'll introduce my fellow panel members in a minute. Just a few words that I think might be in order. Thank you to the university and to Julia, of course, for being such a great host and organizer, to the attendants. If I've been told in 1999, when I started to my career as a competition lawyer, that I would stay here, I know there's other lawyers who are not competition lawyers here. By the way, I'm not saying that everyone in the audience is a competition lawyer, but certainly there's so many talking about procedural rules. Certainly 20 something years ago, this would have been unbelievable, right? At the time, it was a challenge for a young competition lawyer to understand the economics and also the administrative rules surrounding what used to be my language, talking to the authorities. And now I, and of course, every young lawyer in the field, we all need to understand the procedural rules. And actually, you can even enjoy the presentations, which is why we are here today. I also remember a minute ago when I was in the US taking my LLM, I was introduced to this concept of the curse of bigness, right? Which is now in vogue. At the time I got introduced to this concept reading, I remember Bork's antitrust paradox. Of course, antitrust cases are normally very large, vast, complex. That means also that there is potentially many affected parties, and this is why we're here. The problem that faces enforcement when there's so many affected parties seeking redress in particular, or any other injunction or other forms of relief, because of course I think there is a broad agreement that a system where every single claim is channeled through a separate proceeding is simply unsustainable. And we're seeing this, of course, in cases that come to mind very easily, like trucks in Spain. I know this is not always is a case where consumers are affected, and I don't lose from sight that we're talking now about access to justice for consumers, but certainly cases where consumers are affected are normally mass litigation situations, and therefore the problem of channeling multiple actions through a sensible system that does not collapse is, of course, a valid, probably the most important policy aim. We in Spain have seen, in the context of antitrust cases, of course, situations where claimants have tried to accumulate actions in one single proceeding. There is, of course, a way to do that, but of course, there's problems in terms that the law forces that the situation and the circumstances of each of the claimants need to be taken into account, and this is sometimes very difficult to be done by the judge. If there are 10 situations, not to say if there are 1,000 or 10,000, there's always, of course, the possibility of assigning claims to one vehicle that, of course, litigates as a sole claimant. We've seen that also in the area of antitrust in Spain. Recently, a Granada court accepted that this assignment through not a special purpose vehicle, but rather a corporate entity that already existed and that aggregates farmers. This was litigation in the raw milk cartel case. That type of assignment was valid. Of course, there is the system of representative actions in Spain that we all know is regulated, not very in much detail, and it's probably not satisfactory the way it is working. And of course, what we expect is how the directive, the 2020, the directive will be transposed, right? This is basically what I expect my colleagues here in the panel to talk about. And we will see how the situation develops in the UK. Sarah, who works for a very successful litigation firm in London, Mishcon, will tell us about the UK. Then Maria Jose, who is a lecturer, a teacher at the University of Paris-Saclay, with a research background on collective redress. That's for France. Joost, who will talk about the situation in the Netherlands. He's a partner with Van Bentem and Koilen. And finally, Thiel who is one of the leading figures in cartel litigation in Europe as co-founder of cartel damage claims. So I think it's 15 minutes each. If we can do that, that would be great. Thank you. Sarah, please.
Thank you. Good afternoon. Apologies that I'm not there in person. It's my son's birthday and a public holiday in the UK, but I hope everything's going well and you're enjoying the sunshine over there. As I mentioned, I am a partner in London. I specialise in competition litigation. And so, as you'll imagine, I'm going to speak to you today about consumer redress in competition damages cases in the UK and go through some of the key decisions that have been reached so far. So to take a step back from that, there are a number of mechanisms for bringing claims in the English courts. There are single claimant actions, which have a long history here, group actions, which can arise in various ways. So we may have a number of claimants who bring a claim and immediately are named on the same claim form. So they're a group from the start. Or after a case is filed with the court, claims can be brought together through various case management decisions. But finally, and probably most significant for today, is that we have collective actions which can be brought by class representatives. So both business and consumer claimants can in principle bring a claim under any of the mechanisms I've mentioned. However, single claimant and group actions tend to be brought by business claimants, while to date, at least the majority of collective actions in the English courts have been brought on behalf of consumers. And so I'm going to focus today on that collective actions regime in UK because it's very much at the heart of consumer redress and what we're doing over here. Our collective redress regime is specific to competition claims and claims brought in the Competition Appeal Tribunal, CAT, which is a specialist competition court based in London. There is a broader regime under which other types of consumer claims, such as data breach claims, consumer protection law, could in theory be brought, and it's under our civil procedure rules. Those are known as CPR 19.6 claims. Anyone who's sort of reading up on what's going on in the UK will know that there's been a bit of a flurry of action in relation to those types of claims in the last couple of years, but that's a whole other topic and another 15-minute session, I suspect. The collective redress regime for competition cases took effect from the 1st of October 2015. Essentially, it is a class action regime that allows for competition damages actions to be brought by representatives of classes of claimants who share common issues in the claim. And the regime was very much intended to open up redress, so particularly for consumers who might otherwise have claims too small to be worth the cost and effort of litigation. In principle, when the loss caused to all individuals is combined and the costs are shared, which are substantial over here, the litigation becomes capable of being pursued. The regime was quite slow to get started. I mean, I mentioned October 2015. It's really started to gain momentum in the last 12 months. We don't have any final judgments or settlements, but we are beginning to really understand the court's approach to granting collective proceedings orders, or CPOs, which are the first major step in collective proceedings. And a CPO is effectively the certification of a class representative and the case itself in order to proceed through to hearing the claim. While the regime is limited to competition cases, it's quite broad within that. For example, cases can be follow-on, where they rely upon the findings of a competition regulator, or they can be standalone, where the claimant has to prove that a competition law infringement has taken place. They can be brought under Article 101 or 102, up to obviously the UK's exit date, and the UK equivalents, which effectively mirror those two provisions. What has been a clear and probably unexpected trend is that a substantial number of the cases are standalone abuse of dominance cases. I mean, historically in the UK at least, those were regarded as at the more difficult end of competition cases, but actually the collective regime seems to really attract those types of cases. From a procedural perspective, one of the early decisions is whether the case should be opt-in or opt-out. An opt-in case is one in which members of the class that is certified must actively choose to join the class within a specified time period. While in an opt-out claim, anyone falling within a class description will automatically be within the class unless they opt out, within the manner that's specified by the court and the time that's specified by the court. Whether cases are appropriate as an opt-in or opt-out has already been a subject of a number of challenges by defendants, and I'll come on to that later on. To give you a sense of scale, to date, there have been 18 CPO applications listed on the CAT website, and that may itself underrepresent the number of cases that are live, because the CAT can take some time to publicly list a case. The cases traverse a number of sectors, but actually quite interesting ones: telecoms, trucks, power cables, car carriers, train fares, chip licensing. However, there is kind of a concentration in two particular sectors, one of which is banking and financial services, and the other is against the digital platforms, which is obviously the most relevant to the discussion today. To give you a bit more information, cases have been filed against Apple, Google, and Facebook in relation to the use of the market power that each has as a digital platform. However, as I mentioned, until last year, the regime was slow. The issue initially was that the first two cases that sought certification were refused. There was a case originally brought in May 2016 by an individual on behalf of 30,000 class members, which I have to say is quite small when you look at the cases that follow, against a manufacturer and supplier of mobility scooters. And in March 2017, the CAT declined to certify that case because it wasn't convinced that there was sufficient commonality in relation to the loss suffered by each claimant. However, in September 2016, a case which I think a lot of people have heard of was brought by Mr. Walter Merricks, who applied for a CPO against MasterCard on behalf of millions of UK consumers that had purchased in stores accepting MasterCard and allegedly suffered increased prices as a result of the retailers who initially pay MasterCard passing on the charges into their own pricing. That case has quite a long history. The CAT initially refused to certify the case in July 2017. That was then appealed to the Court of Appeal and then the Supreme Court. The Supreme Court finally gave its judgment in December 2020, so over 4 years after the case was filed. The Supreme Court disagreed with the CAT's test for certification, and in particular, the heavy emphasis that the CAT had placed on the claimant to specify how damages would be distributed at that very early stage. So as a result, the way our court system works is that the Court of Appeal, Supreme Court, sent that case back to the CAT to be reconsidered. There were a few additional issues raised, and then a CPO order was finally granted on the 18th of May, so just a couple of weeks ago, and that case will now start to progress through to a defence from MasterCard. This had quite a chilling effect on the regime for a number of years. So there were a few cases filed in 2019 that were stayed pending the appeals in the Merricks case. However, following the judgment in 2020, there were then 8 cases filed in 2021 alone. And in the last 12 months, 7 cases have been certified, with others pending hearing or judgment, possibly even before the summer break. And it has to be said that those cases have moved much more quickly. So I'm involved in a case that was filed in November 2020, and we had certification in September 2021. So less than a year later, the appeal has already been dealt with because it was expedited in order to move things forward. And you can see there's a real trend to it picking up following the sort of Merricks gates opening. Another important aspect of these cases is case management by judges in competition cases has typically been intensive, and that as cases have become more complex, the judiciary's increased their oversight further, particularly in collective cases where a panel is assigned to the case to case manage effectively from the start and will be involved in all key decisions. And we have 3 judges, in fact, so we have typically 1 High Court judge and then 2 other members who may have other skills. So it's not uncommon, for example, to see an economist or an accountant or an industry expert on that panel as well. Starting with some of the basics, there are 2 conditions for the grant of a CPO. The first is known as the Authorization Condition, and that relates to the person seeking to bring the proceedings as the class representative and whether or not they're suitable. that actually hasn't been the subject of a great deal of challenge by defendants. Representatives, it's pretty open in terms of who can be a representative. They don't need to be a member of the class that they represent. What has been made clear through judgments is that the CAT is happy to approve either an individual, a corporate entity, including a special purpose vehicle set up for the purposes of the claim, or a representative body such as a trade association or a consumer association. And we have examples of each of those within the UK already. There is a leaning towards individuals who have a degree of sectoral expertise or come from a consumer policy background, but that's actually more the choice of the teams putting those cases together than the CAT's preference. The second condition, which is a lot more contentious, is known as the eligibility condition, and this is where the CAT considers whether the claims are eligible for inclusion in collective proceedings. And it's quite a wide-ranging look at suitability. So the CAT is required to find that claims are brought on behalf of an identifiable class of citizens, that the claims raise common issues, and that they're suitable to be brought in collective proceedings. Almost all of the cases brought today have been challenged on this basis, with the exception of the Apple case, which I'm going to come back to because obviously that is quite relevant to today's discussion. Many of the challenges have related to whether the cases raise common issues, and in particular, whether there's a common methodology for establishing damages. The court made clear in the Merrick's MasterCard case that class members' claims need not be identical, but they have to raise at least similar or related issues of fact and law. How this has been dealt with in some of the cases already has been by the establishment of subclasses, where there are a number of common issues across all the classes, for example, the infringement of competition law, then certain issues which apply only to one subclass, which may go more to the damages that each subclass should be awarded. Whether a case should be opt-out or opt-in has been a big issue, and a class representative seeking an opt-out case, which has significantly been the preference, will need to demonstrate to the court that the opt-in class is more appropriate than that opt-out is more appropriate than opt-in. However, the CAT has a wide discretion in determining what will be appropriate in the circumstances of the case, and that has gone up to appeal in a couple of cases. Some of the observations that have been made are a large class with small individual recovery is likely to be seen as more suitable for opt-out. Opt-out is likely to be seen as appropriate if the claim would be unlikely to attract enough class members at the outset to make it viable. And the CAT will look at the characteristics of the class that's sought to be certified. So for example, in the case that I'm involved in, which is an abuse of dominance case brought by an individual, Mr. Justin Lepatterell, against British Telecom. It's an excessive pricing abuse case. And the class concerned are not exclusively, but predominantly individuals. There are some small businesses within it. But many of our class don't have access to the internet. And it was very material to the court that the class was substantially consumers, and that fact of not having access to the internet and not therefore being as accessible to do an effective case book build on the case. By contrast, the Mclaren case, which is in relation to car carriers, concerns both business and consumer class members, with some substantial businesses in the class. And the CAT ultimately made an order to proceed on an opt-out basis, but observed that some of the larger business class members might have been better brought as an opt-in. They made a discretionary decision that they would allow it simply because of the overlap between the wider consumer and small business class. In the X cases, which will refuse certification on an opt-out basis, the court was swayed heavily, but among other factors, by the fact that the class would have been businesses capable of bringing claims if they wanted to. One of the key criteria in determining whether a case is suitable for opt-out or opt-in is the strength of the claim. But it's important to realise that that's not a full evidence-based assessment, but really whether the claim as it's described in the application for a CPO, and if you assume that the evidence that the class representative refers to is then available in due course, would the case likely succeed? In the recent FX claims I've just mentioned, the CAT declined to certify on various bases, one being that really the class probably would have brought claims if they wanted to. But also the cases, it viewed the cases as so badly pleaded that it wasn't possible to determine whether the claims had sufficient strength to progress. It also rejected an argument by the class reps that the opt-in mechanism was impractical because of a lack of sign-up. So in that particular case, the law firms concerned, and there were 2 cases brought in an effective carriage dispute, as I understand it, gone around the market seeking to build a book of claimants and had been unable. But the viewpoint was taken that actually it wasn't so much that it just wasn't suitable for opt-in, but rather that it just wasn't a case that those particular businesses wanted to take. And the CAT observation that access to justice shouldn't be forced on an unwilling class. So I have to say, between the cases, there's quite a lot going on there, and it really is very fact-driven by the CAT and what it views as the strength of its assessment of opt-out versus opt-in. As a related point, almost all of the cases involved a strikeout or summary judgment challenge by the defendants. These are effectively challenges directly to the claim, in which the defendant argues that the claimant has no reasonable prospect of succeeding at trial. Interestingly, in the Apple case, the defendants chose to agree to certification, and they're not contesting whether or not there should be a CPO. Instead, they are challenging the case itself, going right into the heart of it. So that case is against Apple in relation to its alleged dominance in the App Store and its ability to charge an excessively high commission and exclude certain apps. The class representative there alleges that the harm has been passed on to consumers by the app developers who use the App Store to distribute their apps. Apple's making various arguments, and for anyone following what's going on with Apple and Google, you'll have seen these arguments being made in various regulatory settings, regarding the need for it to police the iOS system and what it offers to developers in terms of a marketplace. And the identical case has been brought against Google, which has not yet been certified, and the CPO hearing for that case is next month. But they are really very substantial cases, and really quite legally complex, as well as in terms of this regime.
So just to remind that you're around 15 minutes. It's fine if you speak for 2-3 minutes more, but we have 3 more. Thank you.
Sorry, apologies. I couldn't see the clock. To be honest, I can skip over. The one last point I would make is that settlements are permitted under the regime, but they have to be approved by the CAT, and we don't really yet know how that will play out. But there are various mechanisms there, one of which is to settle, and there are drivers on both sides. There's also a mechanism whereby the UK Competition Authority can reach settlements as part of its enforcement action, and we have seen some low-level settlements in that way. So apologies, I've gone slightly over, but I can finish up now.
It's now Maria Jose's turn to inform on fronts. Thank you.
Thank you very much. I would like to start by addressing my grateful thanks to Julia Sudraov, the Organization Committee, and the University of Deusto for the invitation to participate in this conference. I'm honored to share it with many colleagues and friends from my small collective redress world and to meet many competition experts. I'd like also to congratulate you on the opportunity of this event in the aftermath of, let me say, the adoption of the DSA and the DMA, intended to be game changers within the European Union boundaries and beyond. The DSA describes herself as a standard setter at a global level, and is intended to ensure that fundamental rights are protected in an online environment and to guarantee independent recourse to judicial redress. Thus, it is very relevant to discuss access to justice, and to draw an overview of the French developments. I will first introduce the emergence of group actions before browsing the resurgence of more traditional tools that have resuscitated in order to overcome the shortcomings of group actions. Group actions were adopted in 2014 and granted to approved associations to facilitate compensation of material damages suffered by consumers in mass harm situations arising out of consumer disputes and certain consequences of anti-competitive practices. The latter can exclusively be following actions, thus allowed in the aftermath of a final decision establishing an antitrust practice by the competition authority, be it national or European, or the review court judgment within a period of 5 years time as from its date. Because of the restricted scope, standing, and remedies, group actions have been then expanded to other fields such as health, discrimination, environment, personal data, and an action of recognition of rights was also passed to seek a declaratory decision before the administrative justice. The French group action is then original in the sense that the proceedings follow a multi-stage process. First, a decision deals respectively with the admissibility and the liability at the same time. Then, only if the decision finds the defendant liable, the judge orders the publicity and opens the opt-in stage. Last, the defendant must proceed on to an out-of-court spontaneous enforcement. Should he fail to do so, a liquidation and judicial enforcement will follow. Whether group actions enhance access to justice in general, and if they will do so in the context of DSA and DMA, remains to be seen. On the one hand, because of the material scope, in every case engaged so far, defendants would argue the case does not fall into the categories allowing for a group action to proceed. And because of the subjective scope, whilst possible, it would be a challenge to protect children as consumers and undertakings within the DSA and DMA respectively. On the other hand, the structure of the group action proceedings has its pros and cons. As the former, they may seek both injunctive and compensatory relief. Moreover, victims are only bound by the res judicata if the decision is favorable to them and they have been actually compensated. Last, in the so-called simplified group action, consumers do not have to opt in. Under some conditions, the judge may order the defendant to compensate its client on an out-of-court basis. As for the inconvenience, there are issues that should be improved to truly facilitate access to justice. First, regarding standing, since only registered associations, about 15 today, can bring group actions, consumer group actions, if the conflict does not match the agenda of the organization, victims won't have their day in court. That is why standing should also be granted to public organizations, ad hoc NGOs, and of course, qualified entities within the European Union. Second, nothing renders group actions more inefficient than the rule requiring an opt-in. Not only people may not be informed and therefore never claim their due, but also they will neither be deterrents nor scheme of illegal profits. That is why we either need an opt-out or a provision allowing the judge to assess the damages on a wide basis, the whole group without limitation to those having opted in, with another provision allowing the judge to decide on the leftovers through either a fluid recovery or the creation of a fund like in Canada. Last, there is neither a specific rule to fund group actions nor to deal with the loser pays principle, which constitute important hurdles when it comes to access to justice. Up to date, according to specific data collected by the French Observatory of Group Actions, 31 group actions have been engaged so far before the judiciary. They concern mainly the consumer field, but also health, discrimination, and data for infringements of GDPR. None concern environment or competition cases so far. 3 cases have been concluded out of court through mediation or transaction. 4 cases have been judged, 3 of them rejecting the claims for reasons related to the scope, and the only positive judgment rendered so far in January this year was in the case of Deusto, a medicine against a pharmaceutical laboratory, whereby the opt-in stage will be opened soon, and it will last for 5 years just to opt in. So France does have an unprecedented device. Nevertheless, the system is inconclusive, and therefore classic tools not only continue to be exerted in parallel, but seem to have been emerged without any articulation, which leads me to my second and last point, which is the resurgence of traditional tools and the emergence of novel devices. In France, there is an array of traditional devices granting some sort of access to justice that have been in place for several decades now. The first series of traditional actions arise out of the Consumer Code that provides for 4 kinds of collective actions and are granted to registered associations only. They allow them to request cessation of unfair practices, elimination of unfair terms, compensations of damages to the collective interest of consumers, which is a pretty original idea, like the diffuse idea in Italy or Brazil, and allows associations to get compensations up to 1 million euros, and last, compensations on behalf of consumers who have mandated the association. But this last device is truly useless because of the conditions that the lawmaker have said. We can discuss this later on. Aside from these actions granted exclusively to approved or registered consumer associations, there are other very classic ways of aggregating individual claims that flourish nowadays when the plaintiff is not an approved or registered association. I have listed 6 of them. The first, very simply, is a strategy based on powers of attorney given to the same lawyer to engage a series of actions on behalf of victims before the civil jurisdictions. These are joint individual actions brought by one lawyer on the basis of the same template and the same strategy. They aim at the connection of the proceedings for reasons of sound administration of justice. Nonetheless, the idea of connection and junction is not mandatory, but a faculty for the judge according to the Code of Civil Procedure. To be more efficient, lawyers have even created platforms to aggregate these individual joint actions. And from an entrepreneurial point of view, it is truly a success story. The same strategy, so I turn to the second one, of multiple powers of attorney given to the same lawyer is more and more frequently used before the criminal jurisdictions, whereby a criminal proceeding is pending. The so-called action civile allows the victims willing individually to claim a compensation for damages caused, for instance, by the fraud, to do so before the criminal justice. Thus, in February 2020, a well-known French bank was found guilty of misleading commercial practice, and 2,300 borrowers claimed and obtained a compensation for the financial and moral claim damages, 20,000 euros per capita. That's not so bad in France. Same in March 2021 for a consumer case. March 2021, a decision in the Mediator case, again, a health-related product liability case. The judges convicted a pharmaceutical laboratory for aggravated deception and ordered to pay 180 million in damages to 4,133 plaintiffs. And thousands of victims of the Dieselgate are claiming for compensation through this path, so this second path. The third way of aggregating claims is based on a very well-established case law, Ligue de Défense, allowing associations to bring actions on behalf of their members or constituents, provided their articles stipulate so, and they obtain a mandate for this purpose. Foreign associations have used this technique to bring an action within the context of a Dieselgate, also in France. A fourth way to access to justice in France are ad hoc compensation funds targeting a particular damage, namely those suffered by victims of terrorism, medically related incidents, asbestos, etc. These structures are often public organizations created by law or regulated by a decree. They are usually financed by the state and social security system and function through a scheme whereby compensation can be proposed to victims on an out-of-court basis. The fifth model is the assignment of claims, which is an old way whereby hundreds of thousands of assigners allow an assignee to bring the claim on their behalf. And this is how an association has very recently initiated a book building operation to obtain compensation for the damage caused by the anti-competitive practice of a very well-known French meal voucher, Ticket Restaurant, after the competition authority had fined her in December 2019. It's a cartel involving exchange of information. And last, an even older mechanism, the trust, is being used in the same case. The trustees here are lawyers entrusted by restaurant owners to exercise their rights and to obtain compensation in the same restaurant voucher case. So the question, are there any chances? I am under the impression that the DSA and the DMA, whilst enshrining new rights, may not be at rendezvous to truly enhance harmonization when it comes to compensation of damages. And therefore, asymmetrical justice will remain true in Europe. And this will be true not only between Europeans and some non-European countries. I think of Dieselgate and the United States, Australia, and Israel, where consumers have been compensated. And we say, well, none in Europe, except for some German, just 260,000. And on the other hand, between European consumers themselves, because there are countries with opt-out systems whereby third-party funders will fund the actions and consumers will in the end be compensated, and the opt-in systems whereby nobody will opt in, and because of that, nobody will fund these cases. The ex-ante position of the DSA and the DMA is to be welcome. Out-of-court mechanisms are facilitated as well as public enforcement. Let's recall, penalties should be effective, proportionate, and dissuasive. Nonetheless, to encourage compliance, the European Union should care about private enforcement first, probably. To end up with a positive tone, let me recall, which is noteworthy, I think that the proposal of regulation on DSA foresees to add the regulation to Annex 1 of the Representative Actions Directive, so that all the member states should have a representative action for the DSA in a couple of months' time, in 6 months' time. But still the latter only is for the protection of consumers. So discrimination, how split in this big group. Thus, more than recalling, as the DMA does, that what is forbidden in the offline world is also forbidden in the online world, the European Union should probably enact ways of enforcing homogeneous right to grant true access to justice to victims, be them legal or natural persons, be the scope consumer or consumer fundamental rights or whatsoever. And in the latter cases, fundamental rights with principles such as in dubio pro actione and the impossibility of procedural national rules to affect the effectiveness of the European Union acquis in the protection of consumers. Thank you for your attention.
Thank you, Maria Jose. Very, very interesting. Also, this list of 6 old ways to, I don't know whether all of those could be translated into the Spanish system, but it's interesting. Jost, I think it's your turn.
Yes, thank you very much to the organization for the invitation to speak about recent developments in the Netherlands. I'll use a PowerPoint presentation. It's here. Do I need a keyboard to go to the next slide? As was mentioned today in the morning already, the Netherlands have become quite a popular jurisdiction for bringing mass claims and competition claims, in particular over the last 10 years. And I think this has been boosted even more in the last 2 years through the adoption of the new representative action. How can I skip to the next slide? Yeah. And I think one of the reasons that the Netherlands have been very popular is that the Netherlands have a very flexible civil procedure, and the Dutch legislator has introduced representative actions for already a few decades ago, so there's a lot of experience. To illustrate the procedural flexibility, there are many different means for bringing mass claims in the Netherlands. And you can tailor the procedural model to your needs. So we have the solo action or the multiple claimant action. Any action can have an indefinite number of named individual claimants. Claimants can even appoint a third-party representative that will act on the basis of contractual mandates, which in Dutch law are basically an elaborate form of proxy. Secondly, it's also possible for any claimant to bring multiple claims, provided they are slightly related, in one action. And this is, of course, the legal basis for the assignment model, whereby affected parties will transfer the claim to a litigation vehicle, and that litigation vehicle will be the solo claimant in the action. The single claimant in the action bring all the claims. Might be interesting to note that under Dutch law, an assignment is an actual full transfer of the claim. So it's a full legal succession, and there's a distinct difference between an assignment under Dutch law and a mandate or a proxy. So these are the basic models that you can use in any normal civil procedure. There are no mandatory rules for doing a thing like this. It's just standard civil procedure, and thus very flexible. Then there are two other forms of bringing mass litigation in the Netherlands. The first is the collective action, which has changed in 2020. And the claimant in a collective action is not the class representative in the Netherlands, but rather a foundation or an association. This could be a consumer organization or a trade union, but it can also be a legal entity that is incorporated just to do a single case. The foundation or association will act in the litigation, and I briefly want to mention the mass settlement procedure in the Netherlands. If claimants and if affected parties and the infringer reach an out-of-court settlement, they can go to the Amsterdam Court of Appeal and ask for a declaration that the settlement becomes universally binding upon all affected parties, and that's an opt-out regime. Still not working?
It was working, and now it's not.
Gone.
To share the screen because the people online can't see.
Now yes. No.
No, we can't see because we have.
All right. In the Netherlands, the predominant model to bring competition claims has been the assignment model. And there is historically a procedural reason that the assignment model has become this big in the Netherlands. And that is that prior to the amendment of the collective action in 2020, there was a statutory restriction in the collective action. And that restriction was that the foundation or association could never claim monetary compensation. It could claim declaratory judgments, it could claim non-monetary compensation, but never monetary, no damages. So that was a big issue in competition litigation because, a declaratory judgment, let's be honest, if you have binding effect, the added value of a declaratory judgment is quite, it's more or less redundant. Also, if you would want to assess the actual damages, the affected parties would have to start individual follow-on proceedings where the damages would have to be assessed. So that is not working. So that's one of the reasons why parties opted for the assignment model, whereby there would be legal succession and the claims vehicle would have full control over the claims, bring all the claims together in one set of proceedings where they could claim actual damages, whereby the purchase price in the assignment would be contingent on the actual success in the litigation. The main case is brought in under the assignment model are cargo, sodium chlorate, paraffin wax. Most of the truckers cases have been brought under an assignment model. As you can see, it's business to business, follow on, and most of these cases have been funded by and brought by commercial litigation vehicles. And in 2011, Dutch Parliament identified that there was a lack of access to justice for consumers. And that is why in 2020, so it took the legislator over 9 years, the representative action was amended. Now the foundation or association can bring any action of the similar interest of a clearly defined group of natural and legal persons. That could be declaratory judgment, injunction, monetary or non-monetary damages, summary proceedings, everything. It's very flexible. It's an opt-out for Dutch inhabitants. It's opt-in for non-Dutch persons. And there is one procedural phase, and in that phase, first of all, the court will decide whether the entity has standing, whether it complies with all the mandatory rules. And secondly, especially if more actions have been brought by other foundations or associations regarding the same subject matter, the court will need to appoint an exclusive representative that will conduct the litigation. And when that representative has been appointed, that's the moment when affected parties have to decide whether they want to be in or out. In regard of standing, there are mandatory rules. The foundation association has to be sufficiently representative in terms of its object, in its bylaws and its constituents, and the size of the represented claims. And that means that you have a form of book building light in order to do this model. So it takes a bit of time to actually prepare the case and bring it. Founders, board members, and supervisors cannot have a commercial interest in this model. So that's very different than in the assignment model. A reasonable reimbursement is permitted. Lawyers, of course, can be paid for the services, external parties, but not the parties that are involved in the association or foundation. And there is a range of mandatory requirements related to expertise, governance, funding, transparency that have to be complied with. Well, there is an interesting registry. It's public. You can see all the actions that have been brought under the new regime as from 2020. And the interesting thing, the total number is close to 40 by now. That is in about 2 years. I expect that many more cases will be brought at short notice. And the interesting thing is it's a wide range of areas. We have various Dieselgate cases, many cases related to privacy, public health and safety, employee rights. Interestingly, many cases against the Dutch central state related to vaccinations, related to all kinds of public order measures that have been taken. And also we have seen the first competition claims appear. Main case that has been brought is the Apple case regarding the App Store. There are 3 competing actions. So the 3 actions will have to, present themselves before the court in what we, jokingly refer to as a beauty contest. And then the court will select 1 or 2 representatives, probably, maybe even 3, to conduct the litigation. And so I do think that we can see a shift here as from 2020, and that is that now consumers are represented, natural persons are represented, and the types of relief claimed are not just damages, but all kinds of relief. So I think this is a very important, a very good development. One thing I would like to mention is that this morning, Miguel and someone else mentioned that how important it is to have access to information, mostly from the US. I can confirm, if you look at the cases in the Netherlands pending, then many of these cases rely on investigations done in the US, and indeed it is very difficult to ask for disclosure in the Netherlands in competition cases. Courts are extremely reluctant to grant disclosure in general. So I can confirm that this is also the case in the Netherlands. And given that you also have to do a bit of book building light, you have to have a sufficient number of constituents in order to become the exclusive representative. Cases need quite a bit of time to preparation time, and I expect that we will probably see far more digital market cases and competition cases in the close future, but everything is at an early stage still. In view of the time, I could say a few words about the trucks cases. Yeah, okay, I will do so. So trucks, of course, is not a consumer case, but I think it's presently the pinnacle of procedural innovation in the Netherlands. And I think the situation in the Netherlands is to a large extent very different than the situation in Spain, where all the courts have been swarmed with truck cases. Well, the Amsterdam court has been swarmed with truck cases as well, but the main difference is that all these cases are brought in an aggregated manner. So we have assignment models with 600 or 1,000 companies that are represented. The Amsterdam court took quite an innovative approach. First of all, they centralized all the cases in Amsterdam, appointed a panel of 3 highly experienced judges that would deal with all the cases in the Netherlands. There is a very proactive case management. The presiding judge, once or twice a year, we have a case management hearing with the presiding judge, and we make procedural arrangement. And then topics are selected, which are common amongst all the cases, which are adjudicated with priority, and then this will end up in a decision that is relevant to all the trucks cases. And the court has more or less bundled all the trucks cases in a few batches. I represent the first and largest case at the side of the claimant. And this is a batch of over 2,300 companies, more than 200,000 trucks. And the bundling of these already bundled actions, that's something new. The court applied a joinder of cases, and I think they stretched the law a bit. I'm not really sure whether you can stretch it that far, but in practice, it works. And this bundling took place irrespective of procedural model and the type of claim. And I foresee that in the future, if we talk about pass-on, maybe the same instrument will be used to deal with pass-on issues. Who knows? And joint cases generally have joint hearings, a common time path. The same judges will make the decision, and the decisions are jointly in all the cases. But there is still some flexibility. And well, this new development of joinders, even between competing claims, in the sense that, commercial litigation vehicles are involved and they don't necessarily have the same interest at all points. And given that all the claimants have to work together in a batch, the court doesn't demand it, but the court certainly appreciates it when we do that. There's a lot of coordination to draft joint pleading notes for the hearing, joint submission, but there are also complications like the situation we had in 2019, where one of the main claimants, CDC, submitted an expert report, and the other claimants wanted to rely on that expert report. The procedures are independent, so it's evidence in one case. Can it be applied to another case? So there's all kinds of complexities, but overall, I think it's good for access to justice. It stimulates quality and efficiency, but you lose a bit of procedural autonomy. Situation in Amsterdam is that 2 huge decisions have been delivered, and those apply to all the batch 1 cases. They will also be applied in the other cases. Another decision is expected on the 13th of July, 2022. This is interesting in the context of the topic we discussed today, because it's a decision on the standing of the various litigation vehicles, validity of assignments and mandates. And one of the interesting decisions that we expect is that the defendants, the truck manufacturers in these cases, have argued that the mandatory requirements for a collective action in the Netherlands, so the one that was introduced in 2020, should be applied to the assignment model and all the other models as a matter of due process. So retroactively, because these cases have been pending even before the legislation was drafted and introduced. So retroactively, all the actions would have to comply with with mandatory requirements for collective actions, which have been introduced years later in 2020. So let's see how the court decides. Well, overall, I think there are many chances in the Netherlands. The procedural models are there. Wide range of cases are being brought. But yeah, as I already mentioned, the big issue is, of course, information, access to information, yeah, lack of power to investigate yourself. So yeah, many of the cases rely on information gathered from the US. That's it.
Thank you, Jos. Joost, I followed your presentation with envy. I can understand now why you are a jurisdiction of choice, right? And there might be, of course, others who know more about procedure than I do, but certainly I see no way but to follow your leadership, right, in this regard. This is much more certain and flexible. Till, your turn.
Yeah, thanks very much. I was just loading the slides. I hope the microphone is working. Okay, it seems to be working. So thank you. I have nothing much more to say after Joost described the litigation in the Netherlands. I'm going to speak about Germany. We as CDC have experience in cartel damage cases in Germany. I'm going to speak about that. But today it's because you may know that CDC, we are focused mainly on really companies as victims of antitrust infringements. But I'm going to speak about the viewpoint of potential damage claims by consumers. And maybe as a background, I'm going to speak briefly about the collective redress mechanisms that are in place, then the alternative based on substantial law, basically the assignment of claims that Joost already described, and finally some procedural law approaches that we see in the competition law field. First of all, yeah, Germany is maybe not necessarily the claimant's paradise. Traditionally, the legislator has taken a rather cautious approach. Typically, the legislator basically reacted against the backdrop of concrete cases where kind of the public pressure was so high that something should change, that something then changed. However, more in relation to really sector-specific regulation, so a rather reactive approach instead of a proactive approach. The first really collective redress mechanism for consumers was introduced in 2005 against the backdrop of the telecom case, which was the biggest public company which was going on the stock exchange, and many shareholders felt that they had been misinformed by Deutsche Telekom and purchased shares at a too high price. There were 17,000 shareholder claims brought against Deutsche Telekom. The legislator then reacted and introduced a representative action model by which parallel individual actions were bundled in one procedure, and they choose a model claimant and defendant. So there's a model case, and the outcome of that model action is binding for all other individual claims. The enforcement, however, based on this model action, the outcome of that model action still has to be done individually unless you have a collective settlement. You also have to register. So it's an opt-in system. It's still in place. It runs out in 2023. And the only really very big case brought under this regime was the telecom case, which was finally settled in November 2021 after more than 20 years of litigation. So not really a success story. The next step was the introduction of the so-called Model Declaratory Action Act, which was adopted in 2018. Again, against the backdrop of a concrete case. Here, the Volkswagen Dieselgate case. There had been thousands of individual consumers that brought damage claims. Here, the idea is actually similar to the Dutch procedure, the WAMCA that Joost explained, that it's of a broad application. It includes all kinds of consumer rights, including antitrust. So this is, let's say, the German version of a collective redress mechanism. Again, we're talking here about a representative action or model action where you have one representative action and the outcome of that is binding for all other individual actions. However, that only relates to the finding of an infringement, so the declaratory action. The enforcement, i.e. the quantification, is still then subject to individual enforcements. And the key features are that representative actions can be brought, however, only by so-called qualified entities. They must be pre-existing consumer organizations. They must be non-profit making. The activity may not be focused on the judicial enforcement of claims. And it's also required that the qualified entity provides secure financing for the litigation, including the potential liability for adverse costs. So you can imagine that the appetite of consumer organizations to bring these actions is rather limited. In Germany, I had a look at the register, because similar to the Dutch system, the individual consumers have to register in the claims register, which is run on the homepage of the Ministry of Justice. And since 2018, so since the enactment of the action, 27 cases have been brought, mainly by the main consumer organization in Germany, mainly relating, there's 2 cases relating to Dieselgate, and the other cases all relate to banking conditions, where you have a pretty easy black or white decision whether a specific mortgage contract is subject to an abusive clause or not. But no claim yet relating to competition law or privacy infringements or the Digital Market Act, DSM, etc. What is important and what has been done in the Volkswagen case is the possibility of a court-approved collective settlement. And this resulted really in a first large settlement for consumers in 2021, where 260,000 individual consumers got a compensation totaling 830 million euros. So that is at least a result. Maybe it was the result that the legislators really pushed for this result, because otherwise everybody had the feeling that it was really introduced and wouldn't provide relevant results for the consumers. So there was a lot of pressure on the parties to really come to a conclusion in this case. Here, just very quickly, an overview. Basically, the idea is you have an action, the individual brought by the consumer organization, the damaged consumer opts into this claims register. This interrupts limitation periods, court proceedings take place, and either you have a settlement or you have a declaratory judgment. In case it's favorable, the consumers can bring individual actions for the enforcement. If it's negative, it's binding for the consumers and they cannot bring an action afterwards. Then in the field of competition, the main feature that we see is this assignment of claims. And I think we are a bit like the pioneers in this case. We were the first ones bringing a claim against the German cement cartel case based on this concept, which is basically substantive law based. So the assignment is known in many civil law countries. It's basically a contract arrangement between two parties, i.e. the victim of the cartel and an entity such as CDC. The transfer of the claim is made by the harmed person or company that will then enforce the bundle damage claims in its own name and at its own risk in one single action. So it is, in a way, opt-in approach as well. The claimant typically takes care as well of the adequate funding and financing. We have seen it as said in Germany in competition law cases, cement cartel, sugar cartel, trucks cartel, lately the timber cartel. But we also increasingly see the same model on traditional consumer protection laws, for example, flight compensation rights, environmental law, Dieselgate. There is a huge action still pending. More than 50,000 consumers have assigned their individual damage claims against Volkswagen to a company called Financial Right. And you also have a case relating a cap in Berlin on the rent increase, because it's only possible to increase the rent by a certain percentage. And so you even have a bundling right or assignment right for renters which feel that they have paid too high rent. The solutions are, like Marie-José mentioned, often IT-based, web platforms. So in a way, you see that new technology also opens access to justice. So in a way, it's not only creating cases, but also allowing for access to justice. The conditions for a valid assignment are basically the contract, of course, the civil law requirements under the respective jurisdiction, and in Germany, at least, also the provision of adequate financing, including the adverse cost risk. And another typical German thing, the registration under the so-called German Legal Services Act. And I'm going to talk a bit more about that, because that was the center of the debate on this whole assignment process. It's basically the question, is it possible for non-lawyers, and we're talking here about non-lawyers, to bundle claims and agree on a type of contingency fee? So this Legal Services Act exists only in Germany. It's regulating legal services providing by non-lawyers. It includes the debt collection, and that is what you typically, damage claims are assets that are then falling under the provision of debt collection services. The main aim of this Legal Services Act is the protection of consumers. And there have been really a lot of contradicting case law. Is it possible? Yes or no? Are there potential conflicts of interest? Yes or no? Which resulted in a situation, or even can the entity, the legal services provider, can they actually enforce claims? Can they do it in court? Yes or no? So very fundamental questions. And as a result, in 2021, the legislator enacted a new act for the promotion of consumer-oriented offers in the legal services market. So the idea is to open up the market to have new IT-driven solutions to enable consumers to benefit from their rights. And the legislator really clarified a lot of key points. For example, that the legal service provider should limit the legal services to the enforcement of the claims, that they can sue in court, so they have active standing and are not limited to out-of-court activities. They can also charge contingency fees, use third-party litigation funding, and bundle claims. I have a citation here from the legislator, which confirms this very clearly. And the legislator also rejected proposals to exclude specific areas of law, for example, competition law, because they are allegedly too complex from this debt collection service. And here the legislator even confirmed that debt collection service providers have a high level of expertise in complex areas of law, in particular regarding the business or technical assessments that may be necessary, such as in competition law. Established offers exist on the market today without any problems having become known. So the idea is to have a broad applicability of legal services acts that can be, or services that can be provided in Germany. So it's not a closed shop, but really open for many areas of law. There have been court cases subsequently, basically the Supreme Court, and in the meantime, 3 higher regional courts confirmed the validity of the assignment of claims model, also in the field of competition law, subsequently of the enacting of the new Legal Services Act. At the end, and that's now really focusing on the pure competition law issues. In Germany, there are specialized chambers, at least. And there's a concentration within the legal system that at each federal state, there's only a handful maximum of competent courts in the first and the second instance. And also at the federal court of justice level, there is a specialized chamber for competition cases. And what is interesting is that these specialized courts are increasingly structuring the procedure across multiple parallel actions. We see that in the German sugar cartel, for example, but also in the trucks cartel case, very similar to what is happening in Amsterdam, what Joost just said, where, for example, in Munich, there is a court that has, I think, 80 or 100 trucks cases on the table, and they appointed, centralized one economic expert as a court-appointed economic expert that will be looking into each of the cases and provide damage estimates. So that's also a quite effective way to deal with the bundled or multiple parallel actions. Similar to what is happening in the Netherlands, there's also joinders of individual actions. So we have the filing of multiple individual actions, often by the same law firm with the same economic expert. Then there's an application for a joinder of the claims under the condition that the claims must be essentially of the same nature, which is typically the case when you have one and the same competition law infringement. Briefly, an outlook. There will be a hearing and possibly already a judgment on 16 June this year regarding the assignment model in a Dieselgate case. I would expect that the actions under the Model Declaratory Action Act remains limited, simply because there is a reduced number of consumer associations that are recognized and that are also willing to take the risk and the financial risk to bring a case. We will probably also see under the bundling model at consumer level damage actions in relation to GDPR or DMA cases, but it's not yet the case. Thank you.
Thank you, Till. If I was a client of all these different legal systems, I think I would buy just pitch, by the way. Thank you also for keeping your presentations to the great time, also to Sarah, who I hope is still with us. I can see her now. I see, of course, that everyone has been able to listen to the different solutions that both the law and also the, let's say, the case management, informal, just talked about. Sometimes judges stretching institutions that are well known and probably taking decisions to optimize the management of the cases that might not fit within the maybe strict scope of the law. I was talking earlier to someone over coffee that sometimes, you know, if you stretch too much the law, then the judge is exposed to future action, right, by the losing party, because, you know, the decision might be null because of not respecting the procedures. And probably that requires also some degree of agreement or consent by both parties that this is, you know, effective and positive for the management in general. I don't know whether there's any question from the floor, but I have one that comes to mind constantly when we think about, and in my opinion, you know, how good it would be if we could bundle cases, we could, you know, manage this not, you know, drop by drop. I think it's on, yes. And which is, you know, how can we deal then in a situation where we bundle a very high number of claims with a particular situation, right, of a particular you know, claimant or a particular action, right? You know, the judge might need to discuss limitation only with regard to a percentage of the claims that have been bundled, or you know, we in our firm we've been advising in the past financial litigation cases, and I hear from my litigation partners that, of course, in those cases where consent is something that needs to be analyzed, right? In contractual responsibility liability cases, you need to analyze consent with respect to each of the contracts, right? So if you bundle a high number of contracts, how can you deal with the specific circumstances of the case? And of course, we hear of cases in Spain where defendants are opposing bundling precisely because they cannot discuss the merits of each particular case, right, bundled. So I don't know how, if you have any experience in your countries, in your jurisdictions, where you can find the right balance between optimizing, you know, economizing procedure efforts by the parties, by the judge, but at the same time guaranteeing the right that every single situation can be taken care of.
Well, first of all, the situation that you mentioned in Spain, where the nature of the claim is contractual and where indeed consent is a relevant issue, I don't think those types of claims are very suitable for at least for collective action, unless there is a distinct, clear legal matter that is common amongst all of those. But in a collective action, you could ask for a declaratory judgment, also under the new system, where you could clarify a certain specific legal matter in a contract, and then that would be common amongst all for all the cases. And to that extent, you can do that collectively. But the moment that the liability is dependent, to a large degree dependent on the individual situation, then the case probably not suitable for collective redress. We've seen this in interest rate swaps in the Netherlands, where a case was brought on behalf of many small companies that had this banking product, and the court said, yeah, this is just not suitable for collective redress. Competition claims, often, especially damage claims, are of course of a tort nature. The tort is all the same for all the parties, so you can establish the liability. Then the question is, can you assess damages commonly? Yeah, that depends probably on the particular case. If a case is brought in a representative model in the Netherlands, then the court can identify categories of affected parties that have been affected similarly, and then the outcome of such representative proceedings could be that there is what I would say a damage scheme by which you can determine how much damages each individual party would get depending on the category. So there's a lot of flexibility there. If you bring the case in an assignment model, then there is, I think, less room for the court to do that, and the court would ultimately have to determine damages for the individual claims, which is a harder job. Still, even common civil law in the Netherlands allows the court to estimate damages and to apply a certain level of abstraction. So I think the court, I'm certain that the courts will handle cases like that. But yeah, at the moment that the individual situation of a consumer is so different, and so the circumstances, the individual circumstances are so vital for determining the outcome of the case, then I think the court would either refer the individual claim to second stage proceedings for determining damages. It would stick to a declaratory judgment and refer the case. And if the individual circumstances even determine whether or not there is liability or claim at all, then I think the court is simply going to deny standing in a group action or in a representative action and say you have to commence proceedings individually. But it's hard to imagine competition cases where the individual consumer would have an entirely different situation than other consumers.
If anyone else wants to make comment or?
No, I think if you look at Germany, it would be more or less the same approach with the representative action. I mean, the whole idea behind it is that you find one representative case that has many or ideally all the relevant features, at least regarding to establish liability, that then can be applied to all other cases. So if you already cannot establish liability and apply the same argumentation to all other cases, then probably the collective redress mechanism is not best suited.
I think it's quite similar in the UK in that it sounds as if you had something that was going to liability in that way or really quite fundamental, it probably wouldn't be suitable for our collective regime. Although there has already, and there's provision already in our rules for a situation where you have a substantial number of common issues. So liability, for example, might be common, but there may be aspects of the damages quantification that are quite specific to, well, either individuals within the class or, and this is kind of one of the mechanisms we use, subclasses, and there can be subclasses set up so that, you know, you have a group, so say half the group are dealt with in a certain way and they've suffered a particular type of loss and the other half are dealt with in a different way. But there's certainly commonality is really critical to these collective cases in the UK in order to work.
Okay, thank you, everyone. Is there any questions maybe from the floor?
For you, for the economic experts. Till, you mentioned that in Germany, at least the Court of Munich has appointed an economic expert. And this is something that has been discussed a lot in Spain. And so we are, since we are here also economic experts and people that are at court and judges, can you give us a little bit more of information about this? How does it work in practice? Do the parties also, I assume, yes, they provide their own expert reports? Do they discuss with the expert of the court? How does it work? How much time do they have for that?
Yeah, maybe I can briefly speak about one case, and then Peter, who is probably closer involved in the Munich case, can speak about his experience, because each court also takes different approaches. And in the sugar cartel case, for example, the Mannheim court has appointed a expert, and that is quite typical for German courts to do that. In the sugar cartel case, Mannheim is one of the courts where most claims are brought because of the seat of one of the cartel members, Südzucker, which has its seat in Mannheim. The court then was, I think there's like at least 15 parallel actions pending, including by large players like Nestlé. They brought a damage action there, for example, quantified the damage. They got, of course, reports back from the defense side, and then the court appointed a expert, a professor from the University of Düsseldorf, who then, based or taking into account the reports by the claimants and the defendants, but also the data, and requested additional data, additional information, and then came up with a damage report, which is currently today and yesterday being discussed before the court, where you had all parties present, including the respective economic experts of the parties. So it was a kind of cross-examination from the different from the defense side vis-a-vis the court-appointed expert, and then the claimants also were present, trying to support what the court-appointed expert had found, because he found a significant overcharge. So that is going on as we speak, probably. In Munich, I think the court was even more direct. Peter, if you want to say it, but yeah. Because Peter is directly involved before the court, I'm not. So.
Thanks. Peter Gusona, I'm a competition lawyer from Germany. And in fact, yes, we have been representing the second case in Munich, which was brought there in the trucks case. It is a trial and error what the German courts do, because we lack rules and we lack experience. And actually, I think sugar, you mentioned till and now trucks, but those are the first cases in private enforcement, competition litigation, right, where the courts actually have the need to appoint on a large scale experts to have the overcharge assessed. What we've seen in Munich is, first of all, a court who is willing to do that. Not all of the German courts are willing to do that. Most of them said, oh no, we make a judgment on the grounds, liability established, and then we move it up the instances. So Munich in the truck case was actually the first and only court in the beginning saying, no, we are, even though we are a civil court, it is our duty in the end to assess, first of all, is there liability? And second, on what basis we place our estimate of the damage, but because that what it will be in the end, right? It will always be an estimation of the damage. Munich did the following. It is all individual claims, right? There's nothing bundled. Of course, there's the big Hausfeld bundling claim there, right? With an assignment model, but this failed because of the assignment model. So it's up in the instances now. Now, right now, the claims that are there in that evidence phase are only single claimants. And there is more than 120, I would say. And the court did the following. It grouped the claimants. So all claims that are only dealing with purchases of trucks in Germany are one group. Then the second group is if there are purchases in other European countries, right? And then the third group is if there are purchases outside the European country. You wouldn't think what claimants are suing for in trucks, but well, let's give it a try. And then they had a hard time finding an expert because the expert was already, all the well-known experts had been blocked by the, you know that, truck producers. So they really had a hard time finding an expert. We and all the other claimants, I also think the OAMEs, the truck producers, had great reservations when we heard of the expert, because he has no track record at all in economic regression. So, well, let's see, trial and error again. And now we are in a phase there where, unlike the original plan where they wanted to cluster the claimants and group it, the court has decided that now the expert opinion has to be served and delivered to all the claimants at the same time. Don't ask me for the procedural legal basis of this. There is none. But at the same time, we don't have any possibility of appeal. So this is kind of it's a strange situation. Jost, you said like the joinder was a bit of a stretch. We have a bit of a stretch here as well. So what will happen, and this is already addressed, we'll all get the expert opinions draft served at the same time. Then we all have the same deadline for replying. So it is again trying to make the individual claims a little more joined and bundled. And then there will be a cross-examination, as Till mentioned in the sugar case. This will happen in Munich as well. But let me end now because I'm extending my time. Sorry for that. Just one major point for me is important when you talk about economic experts. The main questions of what the economic expert has to assess is not uniformly regulated or addressed, right? Here in Munich, for instance, we had a huge debate that the expert decided to only rely on the data of the producers. So the claimant data is irrelevant for this expert. But since we lack any regulation there, right, there's hardly anything. Of course, you can appeal it later, but the first expert opinion in the truck case, maybe even in Germany where we have a number, will be relied only on the data of the producers. And those are the questions that bother me as a practitioner when we talk about expert. The procedure we'll figure out, but those are, we lack standards for the economic assessment. Thanks.
Yeah, in Spain, we thought about court-appointed experts sometimes, because you can file a motion for that to happen. And it's always a question whether who is going to be the expert, because normal practice is that the court would call the local economists association, and then they run a list. So the next one on the list would just be your expert, and that can be an accountant, you know. So it's quite, I mean, very risky, of course, no? Very risky. There's another thing that came to my mind during, we have 5 more minutes, Julia. Julia's the boss. Which is how in these very large cases, courts can handle the huge amount of data that can be at stake, right? I mean, what type of quantum processor does the judge need to process, right? I mean, I'm joking here, of course, but how can you handle such magnitude of data? At the end, data is evidence, right? Have you experienced any trouble with the problem of handling such vast amounts of data in these cases?
Well, first of all, the Amsterdam trucks proceedings are conducted on the platform of the Netherlands Commercial Court, which it's not officially a Netherlands Commercial Court case, but the platform that has been developed for it has been used, and it means that at the end, all the briefs, everything are uploaded in a digital environment. Our OCRs you can read, all the briefs are searchable, everything. So already for the briefs, that's very helpful. But the court, one of the agreements that we reached with the court and between the parties was that huge quantities of data, such as transactions, underlying evidence of an economic report, assignment contracts, thousands of them, would all be submitted on data carriers. These data carriers are lodged at the Amsterdam court, but I'm certain that unless there is a strict need for it, they will not have a look at it. That has been expressed. And what the court has suggested is that they will not have a look at it unless there is a clear debate, a clear issue related to specific data in there. In that case, a party would have to mention the specific issue and perhaps even submit a screenshot of the particular document where the, or data in the submissions, and then the court will have a look and decide on a particular issue. Also, the parties tend to respond, tend to submit certain issues on an aggregated basis. So there are 200,000 transactions in the first batch. That means that the truck manufacturers had to review 200,000 trucks transactions for their statement of defense, and they've done so with IT assistance and on an aggregated basis. So the defenses are also on an aggregated basis. This is the way the court has been handling it so far. Whether there will be a need for the court to actually have a look at all the underlying data, I don't know. It very much depends on how the debate will evolve, but as of yet, there was no need for the court to do so.
In the UK, we have a long history, obviously, of extensive disclosure of both documents and data. And while the court can access all of the documents in quite organized ways, the data tends to go directly between the parties. So, and actually at times directly to the parties' experts. We've gotten to a position now where disclosure has actually gotten slightly unmanageable. And so the courts have been encouraging the parties to look at ways of restricting it to what's really necessary. And one of the things that is developing, particularly in the last couple of years, has been a concept of expert-led disclosure, where the experts for the parties will get together and discuss exactly what is needed, rather than sort of going in with we want everything that's relevant, which had there was a point in the UK where it was getting very like that, to actually, as an expert, what do I really need and want? And the experts then agree it and then go back to the lawyers to formalize that. And that is leading to quite sort of a narrowing down of what is being passed around.
Okay, so thank you everyone, right on time. That's it. Thank you.